I think we are ready to get started. Hello and welcome to So a Neighbor Asked, a monthly series from Mountain States Legal Foundation, where our attorneys here answer your questions to help you understand the Constitution, the law, and the principles of liberty. From our beautiful headquarters in Colorado, we litigate cases across the country at every level, especially ones that are going to make a difference in our country. My name is Stanton Skrjanek. I'm the communications manager here at Mountain States. I'm delighted to have you all join us. I am joined by Mountain State's own Deputy General Counsel, Sean Nation, the Director for Mountain State's Center to Keep and Bear Arms, Brian Abbas, John Runft, who is a member of Mountain State's Legal Advisory Council, and we have a special non-Mountain States guest that I will let Sean introduce.
Yes, we're delighted to have with us our friends at the Southeastern Legal Foundation, Braden Boucek. He's out of Nashville, Tennessee. We work together a lot, and we have very similar interests in preserving liberty, and we're delighted to have him today.
Thanks for having me.
Marvelous. Thanks for being here with us. So, gents, I'm just going to get straight into it because there's a lot to cover today. So a Neighbor Asked, what is the Supreme Court up to next? What's on the docket this term? What are we focused on? What should Americans care about? And the way I'd like to do this, I know that each of you fellas has a specific case in mind to talk about. So we'll just kind of go one by one, but everyone feel free to chime in on and talk about a case. I know that a lot of what we're doing is interesting today. Sean, you're our deputy GC, so I'll start with you. What is the case that you're following? What's it about? Why should Americans care?
Yeah, absolutely. So thus far, the term is shaping up to be a little quieter than some of the previous terms, but there are still some really interesting cases out there. One cert petition I'm watching. So the court hasn't agreed to hear it yet, but we have filed and argued that they should, is called Coalition for TJ, v. Fairfax County. And it involves what are on the surface, non-biased, non-racial qualifications for a magnet school, but they were done specifically to reduce the number of Asian kids that got into the school and increase the number of minority students. And while it's facially neutral, the effect is ultimately discriminatory.
What do you mean by facially neutral?
Sure. So they did things like set aside a certain number of slots for every feeder middle school that would feed into the high school. They would do things like they got rid of certain standardized tests that they looked at before. They got rid of letters of recommendation, things like that. And they did so ostensibly to make the high school look more like the rest of Fairfax County. But you're not allowed to do that. You're not allowed to consider race and racial balancing in education. And
I don't know if the rest of you lost our beloved general counsel.
Something happened.
I don't know, but I think he was about to go on to something.
Fourth Circuit came out about a month before those cases came down. So we've done two things. We've asked the court either to accept the case and reaffirm those cases, or do what's called a grant, vacate, and remand, which is where they basically say, hey, Fourth Circuit, you messed up. Do it again in light of the Students for Fair Admission case. And I suspect that's ultimately what the court will do. You can never really predict. It's the Supreme, gambling on the Supreme Court's a good way to lose money. But that's ultimately what I think they'll do. Now, in terms of a case that they've actually, go ahead, Tim. Sorry,
Sean. I think we lost it for just a hair bit in between. They're just talking about it, and I had a follow-up question to something you said earlier, and I want to make sure I didn't miss anything. So this whole concept of like nothing about their policy is explicitly about race, but it's pretty clear that their intention is to reduce a certain number of students within a racial group, that intention is illegal?
Yes. Yeah, we have our equal protection clause and our equal protection practice here at Mountain States. It's really important. we of course recognize that we don't yet have a colorblind society, but race is not a biological concept. The amount of, pigment in your skin doesn't make you any different from any other human being. And that's a really important value that America has. We haven't always lived up to it. That's just history, but we want to get there. And one way to get there, the way to get there is to stop making decisions based on race. And that's what we are urging the Supreme Court to do.
Well, what was that quote? I think it was by the Chief Justice. The best way to stop racial discrimination is to stop discriminating on the basis of race. It's that simple.
It's pretty close, yeah. But yes, that is Chief Justice John Roberts. He reaffirmed that in the Students for Fair Admission cases. And, it really is important, I think, even at the high school level, which is where this case would sit. So ultimately, I'm not sure the Supreme Court will agree to hear the case in full, but I think they will probably tell the Fourth Circuit to do it over again.
To do it over in light of the decisions they made this year about affirmative action at colleges.
Yes.
Okay.
So one case that they're going to be hearing, I believe, as soon as next Wednesday, is called Securities and Exchange Commission versus Jersky, I think is how you pronounce it.
Jersky. Yeah, I'm looking at this too on my notes, and it looks a little weird.
Yeah, it's in any event, I'm going to call it the SEC case, not football. Securities and Exchange Commission. So
listen, I'll always talk about the SEC, whether it's one or the other, but I prefer to if it's football. But please continue.
So back, if you remember, in 2008, there was a stock market crash, and there was the legislation that came after the stock market crash, and the Dodd-Frank bill was a big part of that. And what that did is it allowed the SEC to have in-house proceedings. So the SEC accuses someone of fraud. The SEC then gets to judge whether they committed fraud, and then the SEC gets to determine what penalty they're going to impose. Judge, jury, executioner. We have a separation of powers in our country, and we don't generally do that. We don't generally allow that. There are some things where maybe we do that, but very rare. And so what Mr. Jersky, who is accused of fraud, said was, hey, I want a jury trial. I don't want an administrative law judge to determine if I did something bad. I want a jury of my peers. That's my right.
An administrative law judge, to be clear, is different from like a judge that you'd go to at any other court. It's specific to that bureaucratic agency?
Yes.
Okay.
So an administrative law judge, or an ALJ, is someone hired by an executive agency, in this case, the Securities and Exchange Commission, and paid by the Securities and Exchange Commission, and answerable really only to the Securities and Exchange Commission. So we have them in other contexts. Immigration is one where you'll hear a lot about ALJs making a decision if somebody has a valid asylum case or something.
Driver's licenses,
Driver's license appeals, things like a lot of more.
The Securities and Exchange Commission too.
Well, for now, what Mr. Jersky and his company argued. So first, they sued in the district court saying, "Hey, we want a jury trial. This setup violates my rights." And the judge said, "Well, you have to go through the whole administrative process first." So the SEC examined what they did and said, "Hey, we're not being unconstitutional. We like what we're doing."
So they basically just say, no, our rules make sense because they're our rules. How before you go on, how long does that administrative process take? Like, the actual court said, before we can decide on this, you have to exhaust your options with the agency. How long does that take?
I don't know. In this case, he was originally, if my recollection is correct, he was originally charged in 2013. So it's now 2023, 10 years later. So, it's not a quick process. So ultimately, he was found guilty of securities fraud, fined a bunch of money, and banned from the market, banned from having a publicly traded company. It's a pretty big, pretty severe penalty.
Yeah.
He took it up to the Court of Appeals. The Court of Appeals agreed that he should have been allowed a jury trial. He won. And now the Securities and Exchange Commission is asking the Supreme Court to say, no, we're allowed to be the judge, jury, and executioner. I am hopeful that the Supreme Court will agree with the Circuit Court and hold that this structure is unconstitutional. It's been combined with a case involving the Federal Trade Commission, where they have a very similar setup.
Before I let some of our others here get into questions, I have one big question for you, or two. I'll have two questions. I'll be fair to myself. The first is, how many, you kind of mentioned something like immigration. How many agencies utilize this process of being their own judge, jury, and executioner?
As many as can get away with it.
Which is a lot, I take it.
We're even seeing that with the ATF now.
Yeah.
Really? That's on a Second Amendment question almost all the time. And that doesn't have an actual judge?
Some things don't.
Yeah, that would be like licensing, right?
Licensing is a big one, but now they're trying to do it for unlicensed individuals.
Okay.
Okay, so at the risk of you guys already answering my question, why should Americans care about some guy who wants to trade securities and exchanges? What about this case is going to affect everyone else?
Yeah, look, it's about your right to a jury trial. It's about your right to not have just the executive branch determine that you've done something wrong and then punish you. We don't allow that constitutionally, right? For certain things like licensing, like, okay, there can be an administrative remedy, but this guy was, and I don't know if he committed fraud or not. He may be a bad guy. I'm not sure, but even bad guys get a jury, right? That's a fundamental Bill of Rights concept. And, we fought a revolution over some of these issues, right? We separated from our colonial masters because the king was engaging in similar behavior. We're not going to allow that now. We should stand, every American should stand for the principle that at a minimum, you get a jury of your peers. That's not that hard of a concept.
So,
yeah,
at least in the Second Amendment context too, like why people should care is what we've seen with the ATF's newest rule that they put out was essentially that they're going to try to convict you in front of an administrative law judge and then take all of your stuff. And then through asset forfeiture and really put the screws to you just because they can.
just pressure you and correct me if I'm wrong, but I'm not a lawyer, but it always seems like when agencies do this, they know they're going to lose, but they're just doing it to pressure you to give up. Am I being kooky with that, or is that like an actual reality?
The process is the punishment, and a lot of times.
Yep.
There's kind of a saying at the street level, like you can escape the charge, but you can't skip the ride. They'll take you into jail even if they're not going to, even if ultimately you're not going to be convicted because they can get away with it.
How scary.
Anton, I would add one comment there. I don't think it's so much an issue of agency intent as it is just the inertia of the system. We're talking about the structure here.
I don't know what's scarier. I don't know if it's scary that the system is designed that way, or if they're actual malevolent agents. I don't know what's more.
Well, the lawyers involved want to win their case. Stanton,
Yeah.
come on.
That's fair. That's
So
fair.
they utilize the system, and that's what we need to change.
Agreed.
I think that's an excellent way to do that. Thank you, Sean. I think those are going to be really interesting cases to follow. I'm going to move straight on over to Braden here. Thank you again for joining us. I know that Mountain States and Southeastern Legal have done a lot of work in the past, so I'm eager to ask you What's going on in the Supreme Court that you're following? What's something that Americans should be caring about in this instance?
Well, one case that I know your organization and mine, joined by several others, filed on was the Loper-Bright v. Raimondo case. And that's a very important case for those of us who care about separation of powers issues. Ostensibly, this is just a case about a group of herring fishermen in Cape May, New Jersey. But what this case is actually about is about the existential threat that many businesses in America, especially smaller family-run businesses, face owing to their own government. This is a case in which, under the Magnuson-Stevenson Act, the agency charged with regulating fishermen, that's the National Marine Fisheries Service, which is an arm of NOAA, enacted a regulation saying that they can place observers on the boats of herring fishermen to monitor for fishing infractions. Now, that's actually not the offensive part of it. The offensive part of it was that the rule went so far as to say that they were going to force the herring fishermen to pay for the cost of having their own monitor, which is, an analogy I saw from the fishermen's lawyers was, it's a lot like being forced to pay the salary of a state trooper to sit in the back seat of your car to make sure you don't speed.
Oh man.
And right, I know. And they only enacted this precisely because the government ran out of money to pay for its own monitors. And the Magnuson-Stevenson Act contains a provision that allows the agency, in this case NMFS, to implement necessary and appropriate regulations. And so what the government was arguing was it was necessary for us to draft this regulation because we ran out of money. And this wasn't chump change. It amounted to about $700 per day, which is more than even a captain would make. So this was a severe threat to the businesses of that were at issue here.
So not only do the fishermen have to endure a babysitter from the government that the government can't pay for, the government's making them pay for the babysitter.
Yeah, I think babysitter is putting it mildly because babysitters can't punish you. You can punish the babysitter. So I think the state trooper analogy is actually more appropriate. And that we still haven't even gotten to the actual issue. When this was raised to the lower courts about the agency's authority to enact this rule, the lower courts acknowledged that nothing from Congress clearly stated one way or the other. This was an instance of what's called statutory silence. So in interpreting whether or not they had this authority or not, the agency said they did based on an ambiguity, and the fishermen said they didn't. And the way that the court sorted out the competing claim was under what's known as the Chevron doctrine. But the Chevron doctrine stems from an old case governing, Chevron was the name of one of the parties involved. But under Chevron, it obligates courts to defer to an agency's reasonable interpretation. So essentially, it places the court inherently on one side of the issue. They start out on the agency side, provided that it's an ambiguous statute. Then all the agency has to show is some reasonable interpretation. And here, what worked was, well, Congress never told us we can't. So therefore, our assessment that this is necessary is entitled to Chevron deference. It is therefore a reasonable interpretation.
So let me make sure I understand this. Anytime Congress is lazy and writes a really vague law, and the agency
Congress never does that. Congress's laws are usually models of precision. No, you're in the right neighborhood. Congress oftentimes, particularly in the modern era, drafts really vague and open-ended statutes and then puts a provision in there that authorizes the agency to fill in everything else. I mean, a paradigmatic example would be there shall be healthcare, and HHS will tell you what healthcare should look like.
Okay, and so the Supreme Court in an older case, Chevron, said, listen, we're not experts, so we're going to trust the experts in the agencies to interpret it as they want to, within reason, whatever that means. So is Loper-Bright, this case about the fishermen, is this going after Chevron? Is that the idea?
Precisely. I mean, the fishermen made two arguments to the Supreme Court that they asked to accept. The first is that the agencies just interpreted this wrong. But the second is that courts just need to get rid of the Chevron doctrine altogether. Chevron has come under hot fire, especially recently, from justices, but also academic scholars and litigants alike, for violating the separation of powers doctrine, precisely because it weights an interpretation on the side of the government, thereby enabling the executive branch agencies to craft their own rules, and which are effectively laws. So it essentially offloads the legislative function to the legislative branches. And the narrow question here is whether or not courts are obligated to start with some measure of deferences to the agency's interpretation over the scope of their own powers, even in instances of statutory silence. And the Supreme Court, signaling that it really wants to get at the Chevron question, told the fishermen that it was not accepting the first question about whether or not the agency was right. It was only accepting the second question, governing whether or not Chevron should be overruled, or at the least, whether or not Chevron should be narrowed in instances like this one where there's statutory silence.
Braden, is there a taking question here with the idea of the government imposing the costs of its administration on the regulated?
It's a great question. It's a great question, but that's not before the court. I know that in another instance, also governing an MFS reg, they had told charter boat captains, so people who take recreational fishermen out, that they need to carry GPS data on board their ship, and then monitor that and send it out to the federal government to monitor people's comings and goings. And the Fifth Circuit said that failed Chevron, but it also said not that it was an impermissible taking, but that it was a trespass in violation of the Fourth Amendment.
So Braden, I'm going to ask a similar question that I asked Sean here. No, that's a big bummer for fishermen, right? But why should the regular American care that Chevron is a thing that it should go away?
Chevron's at play anytime someone is caught up in an argument with the government about the scope of the government's own powers. So it makes it much, much harder to challenge an agency's action if the reviewing court, when it reviews it, is going to start with the default understanding that the government only has to come up with a reasonable interpretation in any instance where a statute is ambiguous. So it matters tremendously. And you said something earlier on that I want to touch base on, that this is, and you're right, Chevron is predicated under the assumption that courts aren't experts in particular areas, such as fishing.
Yeah.
And so they want to defer to the quote unquote experts. Of course, this totally sets aside the fact that, to John's point, that these are actually government lawyers who want to win. So they're not disinterested experts. They're people trying to win a case and grow their own power. So I think it rests on the fiction that these really are just neutral experts. And I can speak to a personal experience here. You guys were talking earlier about, where do we see these administrative law judges? Where do we see these administrative law forums? Well, they're everywhere. This is the face of a man that has actually appeared before an administrative court for the Tennessee alarm systems installers. Okay. I challenged a determination on behalf of a guy who had invented a computer facial recognition software designed to keep sex predators out of kids' daycares. And the Tennessee Board of Alarm System had told him that he had, in fact, impermissibly installed an alarm system no different than a burglar alarm, even though all he was doing was coming up with the computer code. And just not to put too fine of a point on it, in the administrative proceeding, when we got to the part of the decision-making stage of it, the experts, all of whom were themselves alarm systems installers and probably not so happy about the idea of another competitor coming onto the market, looked around at each other and said, what is the definition of an alarm system? So the experts didn't know what the definition was. They even turned to the administrative law judge for the Board of Alarm Systems Installers and asked him if he knew the answer, which of course he didn't. In fact, the only person in the room that had the definition handy was me, who was representing the non-expert, the regulated party who was claiming he didn't have an alarm system. So I can tell you from personal experience that the fiction that Chevron rests upon is exactly that. These are not disinterested experts. These are interested regulated parties, oftentimes looking to fence out in competitors rather than fencing in themselves rather than fencing out incompetence.
I'm starting to see a trend here of the Supreme Court, maybe not a theme, but definitely a trend that right now, as it stands, a government agency can interpret the law, enforce its own rules, and judge whether or not it's there. And then when that doesn't work and it actually does get to the actual courts, they're going to win because Chevron says we defer to you anyway. So it seems like there's almost like a ratcheting effect on Americans in the bureaucracy that's going to be before the court this year.
Yeah,
Yep,
that's
very
true.
much so.
Yep, that's true. And the through line from like cases like Loper Bright and the cases like Jarchese and even Nebraska v. Biden or West Virginia v. EPA, a lot of these major cases that have gone up in the last few years is that the Supreme Court is increasingly growing leery of these doctrines that implicate separation of powers issues, where you've got the administrative arm of the federal government, which is an executive branch agency, exercising what look like lawmaking functions in some case, or in Jarchese, the judicial function, and thereby displacing other bodies within our constitutional system.
Wow. So
And I would add on to that. You were talking about ambiguity. One thing that courts have let the agencies do is manufacture ambiguity, where none really exists. And that's really getting at the heart of letting agency rulemaking effectively become effectively take over Congress's role, because Congress can delegate authority. I don't like the delegation doctrine, but whatever, that's a separate issue. Congress can delegate authority to make rules with a guiding principle, and the agencies can say, I think this is ambiguous, so I'm gonna fill in the blanks and do what we really want to do. And so last year we saw with the Waters of the USA rule, that was essentially what the EPA had done, was manufacture ambiguity where none really existed.
So I want to, all incredibly fascinating. I think we could talk about this for a while, but I know we've got a couple more cases to get to. I'm going to shift gears here a little bit. John, thank you for joining us. I know that you've got something actually really interesting to talk about. So I'll leave the floor to you here, and I'll ask my questions intermittently. Also, before you do, sorry, I just want to make sure, for those of you who are watching us live, there's a little Q&A portal down at the bottom. If you've got a question, go ahead and type your answer in, your question in there, and we'll do our best to answer it. Go ahead, John.
Yes, I thank you for everybody being here. I've been, as you suggest, watching the court for some time. In fact, I first appeared before the United States Supreme Court in 1976, perhaps before some people here were born. And I've been watching the court, and there is a trend here that more or less recently has become, I think, extremely deleterious to the court itself. Braden observed that the Supreme Court lately has been focusing on the separation of powers issue, properly so, and has been pulling back some of the doctrines of the past, such as Wade versus Roe, things like that, where the court expanded really far beyond its jurisdiction, finding things that don't exist. But anyway, in this case that I've looked at is a tax case, the Moore case. And the case itself, the issue is whether or not a one-time tax on accumulated post-1986 income, deferred income, received through controlled foreign corporations by U.S. stockholders owning 10% or more of the shares is actually a tax on income under the 16th Amendment. The proponents, the plaintiffs claim not. They say it's a wealth tax. In short, it's quite clear that it's not a wealth tax. It doesn't tax the Mandatory Reparation Act, or MAT. It doesn't tax wealth, it doesn't tax value. It is purely a tax. I think it's a pretty open and shut case.
Okay.
But the underlying issue is something else that has occurred. Earlier this month, members of the Senate Judiciary Committee, Senator Dobbs and others of the progressive stripe, challenged Justice Samuel Alito's remaining on the court, sitting on the court for the case, because of his relationship, which has nothing to do with the merits of the case, with one of the attorneys appearing on the case. This appears to be following up. Now this is serious because it's the Senate Judiciary Committee, and they want him to recuse himself from the case, not sit on the case. Now
Make
that's
sure I understand this. Members of the US Congress, Senate,
the Senate.
they're
Judiciary.
saying that Justice Alito has a relationship with one of the attorneys on this Moore case. And because of that relationship, he should step down for the case, recuse himself.
Recuse himself. And one could say, well, a couple of senators have got a burr on their saddle or something like that. But when you look at it, it's part of something that's been happening over the last 3 or 4 years. As the court has become ostensibly more conservative, many of the people of the progressive stripe have been accusing the justices of improprieties left and right, the gifts they receive or the travels they take, despite the fact that other justices of the more liberal stripe have taken even more trips. I'm not going to go into all that. The point is, we're getting a lot of this type of criticism now, which really affects the separation of powers, but directed at the court itself, not on external issues. This goes to the separation of powers of the court itself. The asking a member of the Supreme Court to recuse himself is far different than asking a member of the circuit court or other courts to recuse themselves, because they can be replaced by other justices in the system. Not so. And this is a court of last resort, and asking any justice to recuse himself can upset the whole judicial system.
That's a serious deal.
Congress didn't create this court. This court
Right.
is of the Constitution.
So, John, what is I forgive me, I haven't followed this issue. What is the relationship? Or is it his daughter or his wife or something? Or is it, just like
No.
a friend?
This man, Mr. Brivens, is a correspondent, among other things, for the Wall Street Journal and others. And he interviewed Justice Alito in a wholly separate matter, didn't even talk anything about the case. And it's a lawyer that Justice Alito happens to know. He doesn't have any special friendship with him, but good God, Alito knows a lot of justice and a lot of lawyers, and there's a lot of communication.
This isn't even like a family or close friend.
No.
This is literally just like a lawyer journalist who talked with him. Oh, wow. That's even crazier than I thought
Well,
it was.
the lawyer did interview, the lawyer, Mr. Rivlin, did interview him on a wholly separate matter earlier. The justices do on occasion, not infrequently, have interviews which they talk about their philosophy, or they talk about this or that. It happens all the time. Justice Ginsburg did a lot of that. In fact, it's talking about the underlying issues of the Supreme Court's ethical duties. They raised, for example, last summer, you remember they were talking about Justice Alito and others having travel friends. Well, Ginsburg beat them all. She had more traveling and more friends than anybody. But look, aside the point, the Supreme Court has long had a doctrine that the recusal decision is left up to the individual justices. And there's no other way that can be. It's very seldom invoked, but the justices have an internal rule on that is ethical. But the duty to sit is extremely important, and it goes directly to the separation of powers. If Congress can start asking justices to recuse or develop or require or demand that the justice develop some sort of objective ethical system that can be raised all the time on objective grounds, then that's going to impinge on the Supreme Court's right to do its job. It's that simple. It has to remain these life appointees, it has to remain subjective based on their own motivation, their own feelings about it, and they will talk to the other justices, but we can't have Congress directly or indirectly impose some sort of objective system that can be tripped at by outside lawyers, members of Congress, and so on.
Yeah, it's as if these politicians expect justices of the Supreme Court to be some monastic monks living in secluded life. This is a matter of an independent judiciary, which Americans have always valued since before the revolution. So I can definitely see why this matters a lot.
And this is again, they chose the Moore case as their fulcrum, so to speak, to raise this issue. And we're going to see more of this, I'm sure. And especially during this rather, somebody mentioned, I won't use the word dull term, but a system that, a session of the court coming up that does not have quite the blockbuster issues that were in the previous session. And we'll see during this session a lot more, I'm afraid, of this sort of attack on the court underneath, so to speak, of its own jurisdiction. And it is, believe me, a matter of the court's own separation of powers, not externally about other cases.
I fascinating. I can't wait to see how this plays out and see how the leader responds further.
I just will add that Alito, as you probably have read, very publicly rebuffed this attempt by Senator Dobbs and the Senate Judiciary Committee in a statement that covered all these issues, made it very explicit, and nobody from the court, I may add, in any way took away anything negative from what he said. Nobody countered that. They were, I guess, if silence is admission, then the whole court's behind it.
Well, and I think his most persuasive point and what he wrote was essentially that all of the lawyers that end up practicing in front of the Supreme Court, a lot of them are former Supreme Court clerks. So if they start excluding lawyers that they know, essentially, there will be nobody practicing before them in front of the Supreme Court.
It is truly reductio ad absurdum.
Brian, you're our last but not least man here with the case. You helm our Second Amendment litigation. What's in the 2A realm that Americans need to be paying attention to this year?
Okay, well, the main 2A case this term is going to be United States v. Rahimi. Essentially, it's a criminal case, and what happened was this defendant was subject to a civil restraining order, and he possessed a firearm while having a civil restraining order, and then he went on a crime spree. Essentially, he's being charged with a whole plethora of state law crimes, including possession of a controlled substance, 3 counts of aggravated assault with a deadly weapon, and deadly conduct with the discharge of a firearm. And so he was being charged by the state, but then the feds decided to tack on the additional possessing a firearm while he was under a restraining order. Now, there's a few issues here. The underlying statute preventing him from possessing a firearm while he's subject to the civil restraining order, the court is going to be determining whether or not that is unconstitutional. And in this case, so I think it is unconstitutional. And essentially, it was just a charge tacked on by the feds because they know that bad facts make bad law. And yes.
Sorry, I want to make sure I get this right. This dude does not sound like a good dude. He does not sound like the model citizen here.
No, so here the issue is so at first he had the civil restraining order against him from possessing a firearm. Obviously, that did not stop him from possessing a firearm because, well, criminals do criminal stuff.
Sure.
So after he had that civil protection order, then he went on and committed a series of crimes. So the state is charging him for these series of crimes, which he is going to go to prison for a significant period of time on these crimes, more likely than not, hopefully the next 20, 30 years or more.
But this Supreme Court case is not about those crimes. It's about the restraining order.
Yes.
Okay.
And so the Supreme Court here, a lot of people are worried that this is going to have the Supreme Court withdraw some of the protections of Bruin. But at the same time, I think that this is a case where we have the Supreme Court that I'm really hoping that they are going to reaffirm the protections in Bruin by saying that, no, a civil restraining order is not enough to make you a prohibited possessor, because that is the only issue before the court. And that's the only issue that really matters, is whether or not a civil protection order, not even a criminal one. So before you ever have been charged with a crime whatsoever, whether or not a civil protection order is enough to make you a prohibited possessor.
Yeah, I guess
And-
that's my big question is why can't a restraining order at least temporarily restrict your Second Amendment rights? I get that. I think that's my question. A question a lot of Americans might have. Why shouldn't that be the case?
Well, if you ask me, this is kind of like a Minority Report issue, right? Like, are we going to start having like pre-crime, like before you've ever committed a crime, like you merely thinking about a crime is a crime, like before? So even with the civil protection order, there was nothing to really indicate that he was a danger necessarily. But eventually he did go and commit these other crimes, but as the civil protection order, one, didn't do anything to begin with. And then two, essentially the burden of proof is a lot lower than in a criminal context. And it's just purely decided on by a judge. And sometimes it can happen without a judge being present in this case, or without the defendant being present. In this case, the defendant was present, but at the same time, it's an issue that the court's going to have to wrestle with.
So I think I'm pretty clear on why Americans care about this, but just for my own edification, just to make sure I'm clear, why should your average Joe, who's not a dirtbag like this guy, care about this case?
I think the main reason, the main takeaway from this is whether or not the government can take away your right to own a firearm in the civil context. That is the main takeaway from this case. And also, if the Supreme Court reaffirms Bruin here, it'll be all around a fantastic thing for the Second Amendment.
Yeah, and I'd add that
Go ahead.
this would have implications for things like red flag laws and, where are we going to, what process is due before you are stripped of your Second Amendment rights?
And especially given the ATF's newest rule, where they're essentially relying on the civil context for turning at your average American into felons, as we were talking about a little bit earlier, where they also want to make themselves judge, jury, and executioner in the ALJ context. This has all sorts of implications on the individual.
It sounds like to me, I've done enough trial work, but somewhere along in the record, way down below or somewhere, that the criminal aspect of this case was leaked to the court or to the prosecutors. I mean, have you checked that out to see there was no leakage of the criminal background here that affected this outcome?
So I would be willing to bet, if you were to give me $1 million, I would bet it all that what had happened here was that and as I said before, bad facts make for bad case law. And what we have here, I would almost guarantee you that whoever was down there in the federal prosecutor's office saw this case come across their desk and was like, oh, well, this is a great political case for us to take, because the only thing he was charged federally with was the firearm possession charge. The rest of the actual serious charges, all of the serious charges are state law charges. And so that's why this case kind of reeks of a more or less political prosecution in the federal context.
Yeah.
I mean, he shot at a Whataburger worker in Texas.
Well, he shot up into the ceiling, but yeah.
But he's going away for a long time.
Talking about those structural incentives from earlier, playing right back into it here again. All the more important for the court to do a good job and uphold its historic decision on protecting the Second Amendment from Bruin last year.
Yeah, you'd think also that the lawyers on our side on this thing would be very, very adamant that about the smell, the stink factor. It seems to me that would be something any judge that's been sitting on any kind of a court for any years understands that. And if the lawyers stress that, I think the judge would take it into account in his judicial discretion.
Perfect. Love that callback. We have some questions here for Q&A, so I'm going to go through them here a little bit. This person has decided to remain anonymous. This goes back to administrative agencies. How often does an administrative agency, without asking, change themselves to become a co-defendant? not sure I understand that question quite
I'm
properly.
not sure I do either. In the context of the SEC case, the SEC was initially the charging entity on behalf of the federal government. And then, so the case would have been, Securities and Exchange Commission v. Jerkasey, I think is how we're gonna say his name. And so then when he appealed, it would be Jerkasey v. SEC. And then since he won, the SEC is now the appellant to the Supreme Court. And so when a federal agency issues a charge, they do it in the name of the agency, not typically in the name of the U.S. government. It would typically be, SEC or FTC or FDA against whomever.
Excellent.
And if you're challenging a regulatory action, like what happened in Loper Bright,
Yeah.
you do that under what's called the Administrative Procedure Act. And there you're going to be challenging, you can actually bring it against the agency, but typically people bring it against the people charged with enforcing the agency. That's why it's Raimondo. She was the head of either Secretary of Commerce or head of I can't remember which, but you're bringing it against the head of the agency, head Commerce.
Yeah. So we have an ongoing case called FAA v. Buttigieg. It changes every time there is a new head of the Department of Transportation. So for a while it was against Chow and whomever preceded Elaine Chow. So yes, that's when it depends on the context, but typically you're going to either name the head of the agency or the agency itself.
Excellent. Brian, this looks like this is directed towards you. Is there a danger that the Supreme Court will narrow Bruen? And how would it do that to cover Rahimi but preserve the heart of its opinion? I'm not going to hold us to the second one, but I will ask you about the first one. Is there a danger the court narrows Bruen?
I don't think that there's a danger that the court will narrow Bruen. I think the court may artfully apply Bruen to essentially guarantee that Rahimi, he's never been convicted of this charge. This was actually brought on a motion to dismiss the charge entirely by his defense team. And so it will really just be the Supreme Court saying, okay, well, this can go back down to the lower courts and they could, and they can now convict him of this because this charge was part and parcel of, or I guess has some kind of historical analogy to other crimes and the 1795 to 1868, something like that.
So in short, we may not get a firm brouhaha, but we definitely won't see a narrowing. That's the idea.
Hopefully.
Yeah.
Okay.
Also, this will be the first time that we really get to see the Supreme Court apply the test in Bruen outside of the concealed carry context that they applied it, that they had used in New York. And so that's kind of another thing that we're looking at is just how is the court going to apply it and then how we're going to use that in the future.
Excellent. I have one more question here that I think everyone is at least interested in because I've talked with you all a little bit. That question is what's going on with the redistricting in Alabama? I don't know enough about this myself, but this person seems to have a specific inclination of that they want to hear from you. So what's the brief background here and what's going on?
Yeah, so the Voting Rights Act has been interpreted to require states that can produce majority minority districts to do so within certain limits. That is an entirely too short shrift, but that's basically it. Alabama after the 2020 census, engaged in redistricting as required, and created, I believe, one minority majority district when it could have created two. And it went up to the 11th Circuit. The 11th Circuit said, you've got to create two districts. The Supreme Court declined to hear Alabama's challenge. Alabama redistricted again and created one minority majority district and one district that was, I believe, 40% minority, but not minority majority. The 11th Circuit then said, no, we meant it. You have to create two. And most recently, the Supreme Court declined to hear Alabama's challenge again. So Alabama should, I believe at this point, will be forced to use a map created by a federal district court for the 2024 election, unless presumably they would have the ability to comply and create their own two minority majority district maps. It's part of kind of our country's schizophrenia over race. We say race can't matter in education and employment, but it must matter in voting and in redistricting.
Why doesn't the Supreme Court take this question up? This seems very important.
It's
Well,
taken
it
it up
did.
in the past. It is important. It has taken it up in the past, and most recently held that the formula within the Voting Rights Act, and I believe it was 1968, is no longer valid. So we no longer have to use what the federal government mandated back in the 60s. They had previously signaled to Congress, like, hey, you guys really need to update this. Congress didn't do anything with it. And then ultimately, the name of the case is escaping me at the moment.
I think you're thinking about the Shelby.
Yes, thank you.
But it's
Yes,
gone
it's
up
Shelby
again
County.
since then, right?
Yeah, which I believe was also in Alabama.
Right.
And so that did away with a lot of things where states, particularly southern states, would have to pre-clear any changes through the federal government. Typically, states get to operate on their own. In this particular area, they would have to get permission from the feds before they did things like change a voting location or even do their districting maps. And so this is kind of the fallout from that it's still working its way through the court system.
Historically, go ahead, Brent.
Oh, no, go ahead, John.
I was going to say it came up again last term, and I think it was Allen v. Milligan. And
Yeah.
the question there was whether the plaintiffs had demonstrated a reasonable likelihood of success that the redistricting plan from Alabama in the 2022 congressional elections violated Section 2 of the Voting Rights Act. And the Supreme Court sent that back down. That's why we're here now. And the Alabama courts, I think you're right, it's the 11th, told them you needed to create another district, and then Alabama didn't do it. So the answer to why the Supreme Court probably isn't stepping in again is because an intermediate appellate court told them you need to adopt this specific remedy, and Alabama didn't do it.
Yeah.
I was just going to say that the Voting Rights Act itself, in its earlier form, probably fundamentally violates, in my opinion, the Constitution itself. But we really have the legacy of slavery, which is still with us today, and there's no denying that. And the courts have struggled with this for many, many years. And the cases in Milligan and Shelby, which Braden addressed, are iterations of this long-term struggle. Pardon me. The struggle is not over, but I believe if one were to look at a tendency or a direction the court will be taking or is going, is that gradually we will relieve ourselves of the Voting Rights Act, since it's already been weakened by earlier decision, and begin to decide these issues on arbitrariness and rationality. And leave it to the states, and then review what they're doing or under one man, one vote concept, and how you set the districts up based on reasonableness and rationality. To my way of thinking, that's the only constitutional way they can ever go. Otherwise, you're going to start having categories of race, which we have right now in that very problem that's in this case.
Yeah, I would agree with that with, a couple of caveats that, we have North Carolina very explicitly saying we're drawing this not based on race, but based on party. And that's why we're having these districts. And, they got their hand slapped for that. And I think possibly appropriately so. I would love to move to a world where, it was done without reference to anything other than head count, but we're not there yet.
A world to work for. So, gents, we are coming up on the closing of our time. I'd like to give you each about 30-40 seconds to give your last minute statements, and then we will close out the session. So I guess we can just go in reverse order. So, Brian, you can start us off.
Well, I'm just kind of looking forward to what happens in Rahimi, and to make light of something earlier, whenever Congress puts into a statute that they're going to leave it up to the agency to determine in the future. When I had a lobbying class, the professor always said that that's what they call the infinite legal employment clause, and gave lawyers employment for the foreseeable future. So
Marvelous. John, last comments?
Last comment would be this. I think the Supreme Court now is narrowing its, if you will, its jurisdiction, and is reversing its previous adventures beyond its jurisdiction into areas of social contexts, which are really the matters of the legislature. And as a result, is probably strengthening its position as the third branch of government.
Love it. I couldn't agree more. Braden?
I think the Supreme Court is continuing to rethink a lot of long-held doctrines that it's held that have enabled the administrative state, and looking to put some muscle behind separation of powers doctrines that have long grown dormant. But for my part, I'm just looking for a world where you're free to fish for herring without having to pay for your own federal monitor.
Perfect. Sean, close us out.
Yeah, well, thank you, everybody. Thank you guys for joining us. We've talked a lot about separation of powers and how we really want to pare back the administrative state. And in the Loper Bright case, Senator Sheldon Whitehouse, on behalf of himself and a few others, attacked Mountain States for being part of I think he said a 40-year mission to pare back the administrative state. And it's like, yes, thank you. I think he took that as as an insult, but that's exactly what we're wanting to do. So thanks everybody for joining us. I hope you all have a great rest of your day.
Marvelous. For those of you who are still with us, you can find us on our website, mslegal.org, Twitter at, I guess it's X now, at MSLF, and Instagram at Mountain States Legal. We'll have this video recorded and uploaded to our website and to our YouTube shortly. So thank you all very much. Have a great rest of your day.
yeah.
Right.